Welcome to FLPA Talks, a family law podcast. We are FLPA, the Family Law Practitioners Association of Queensland. Family law is a wonderfully rewarding career, but is not without its challenges. Join us as we explore the issues that impact on the practice and well-being of family law practitioners. We hope our episodes will not only inform and inspire you, but encourage you to reach your potential. Enjoy this episode.
Hi, I'm James Bailey of Wallace & Wallace Lawyers. On behalf of the FLPA Board, I have the pleasure of welcoming Sarah Cleeland of Sarah Cleeland Mediations. Sarah is joining me today to speak about the topic, what you need to know about recommending parenting coordination to your clients. Sarah, welcome.
Hi, James. Good morning.
Good morning. So, Sarah, parenting coordination, what's it all about and when do we recommend it to our clients?
All right. Thanks, James. So, parenting coordination is really designed to help parents implement the orders that they have. So, I can't speak on behalf of every parenting coordinator, but for me, it probably becomes most relevant and most impactful after final orders, but it certainly doesn't mean or preclude parents from obtaining those orders at an interim stage, and we'll talk about that in a minute. But in terms of what parenting coordination is, so really assisting them in putting into place and living the orders that they have, so implementing the orders, and ironing out the tweaks that may arise in any drafting, for example, holiday time, living the changeovers that we say, do at the local McDonald's. Well, what's that actual experience? So a lot of those tweaky things that we might think are trivial, but because they're living them, they can become problems, and we assist them in resolving those. We work on assisting parents in resolving conflict. So we do that through education, giving them information and tools. We work a lot on their communication. So we look at whether they're communicating through an app or text message or email. We actually read those, your app messages. We usually get access to it or permission. We read your texts, we read your emails, and then we work through, well, what are the problems that are arising? Again, I think as lawyers, we can take it for granted that this is going to, after we go, they're just going to do this and live this, and they'll play nicely after court. And there are areas that we can step in and say, hey, maybe you should have written that differently. How could we write that in a way that elicits a better response? So we talk about responding to messages, for example, not reacting to messages, not being inflammatory. So the PC really steps in, I think, when the lawyers go away, the courts go away, and we become the person that assists them to start working together again, rather than using, as I said, mediators, judges, lawyers as the person or the intermediary, if that makes sense. So that's why there are a few PCs that prefer final orders, and I understand that, but you can also work at the interim stage. In terms of then assessing, is your client or the parties suitable for interim? You want to talk about that for a moment? So in terms of suitability at interim, what will happen is you might have received a recommendation in a family report often. These parents should engage with a parenting coordinator. You might have attended a mediation, and part of the mediation interim agreement or parenting plan is give them the assistance or get the assistance of a parenting coordinator. That is fine, and we do all the same things, but the difficulty can be if at interim stage they are living those orders that they have, but they're not the orders they want because they're actively seeking something different, a change in residence or, substantial time. And at the moment, perhaps one parent's only having weekends or something like that. You're going to be working with them to do what we're supposed to do, assist in the implementation of the order they have, assist in communication. But while you're working with them, their mindset is often, thanks for listening, but I really don't want to do this. I just want to talk about, can we change residence? Can we make it shared care? So there is a place for it at interim, and if parents will adopt your recommendations and advice and work with you. They can improve their communication at that interim stage. They can make changes at the interim stage. And sometimes even because they're communicating better, they may even ultimately resolve the final outcome. But we can't, as PCs, be part of that, in inverted commas, mediation process. Where it's a not confidential process, it's a reportable process. So necessarily, if we start talking about, hey, let's talk about changing these orders substantially, we traverse into an area that is really not supposed to be reportable. It is confidential. It's a settlement discussion. So that's why at interim it's really important that if lawyers are going to recommend it, think through and understand themselves, hey, don't use the PC to mediate, even though most PCs probably are mediators and we have that skill set. Make sure your clients understand it. I know the PC will explain it anyway, because you don't want to traverse into that area. It might not be suitable at an interim stage, and might be better used at a final stage. But certainly, yeah, in terms of, I have maybe 16-ish families I'm working with at the moment. Probably a half-half, to be honest, at the moment. Some are interim in terms of interim and final. Hand on heart, it's easier to work at a final stage because you're not dealing with that extra dynamic of they're listening to you, but the interim ones, their brains are somewhere else because they're, like I said, they're totally thinking, I want to change these orders. At a final stage, you can really focus on the task at hand. So, but it can be done. Just stay in your lane as the PC. Make sure the clients understand as well, I'm here to do this job. If you need to go to mediation, well, then I've got to send you to someone else to mediate those issues. Reportability. So what can lawyers get from a PC? Is probably something to talk about. So in terms of, as I said, it is reportable. A lot of us, and I know I'll talk about myself personally, I write, and a lot of us do write, an outcome letter after the end of every session. I say to my PC clients, and I write it directly to them. So at interim stage, they've got lawyers. The lawyers know I'm in it, but I deal with their clients. So it's again a funny dynamic because we're so used to, as lawyers, writing to lawyers. So I write to the clients, but I say to them, of course you can take it to your lawyers. It's not confidential. So I write an outcome letter. I'll indicate any agreements reached. And when I say agreements, I mean, well, we decided to change the changeover from 5 to say 5:15, not fundamental things. So we put outcomes in it, we put agreements in it, and we usually set out homework tasks. So we've asked the parents to reflect on this. We've asked the parents to read this, talk to their lawyers about this. So we set that out. If you've got clients going through PC, either ring the PC, which you're allowed to do, or email us, and just say, hey, have you been, is there a letter you've been writing to my clients? But typically the client should be giving it to you anyway. So it is reportable. So after final orders, we'll still do the same process. We link in usually with the ICL. I know as soon as I see there's an ICL in a parenting coordination matter, particularly at interim, we let each other know we're in it. Again, it's usually an email. The ICL usually emails you the orders, or if they've got leave, the family report, which we find really helpful. And then they might say, how's it going? How many sessions have you had? Is there anything to report? So we're working with the ICL. I know family report writers sometimes call us if there's an interim stage. So it's been recommended. They're about to do, for example, their final report ready for final hearing, and they'll call the PC, hey, I see you're in this. Yep. And again, it's reportable. You're on record. So they will have a conversation with you. That's happened. So that's the process in terms of that. You're asking about, I think, disclosure was one of the issues I saw in the brief. So disclosure meaning, yes, being reportable. If you want to get our notes, you can. Please don't issue subpoena to us. I think any of us. But I think the best way, though, is to get those outcome letters, to be honest. I know if you tried to read my notes, they'd be dreadful. But yeah, I think the outcome letter, and most, as I said, most PCs do that. So, but I can't speak to everyone. I can only speak for myself. Um, Anything else you want to ask me?
Yeah, no, that's fabulous. Really interesting. Can you tell us about what is the process of getting a new client?
Oh yeah.
What do you do in terms of intake? What do you read? What are you told? Tell us about that process. Fees, how does that work? All of that
Okay.
kind of stuff.
So sometimes we will get inquiries from parents who either don't have lawyers, but that's rare. Most of the referrals we receive is because the lawyers have gone and got an order, or they're heading to court and they want to check that you're available, you can do it. Some lawyers even ask us to check their orders to make sure, hey, if is this the right wording for a PC order? So we usually get the referral, as I said, from a lawyer who then sends us a copy of the order and says, hey, you've been appointed. Have you got availability? Sure. The first step then is we make contact with the parents directly. We send them a parenting coordination agreement. We send them, obviously, our fee summary and a bit of information about PC. They usually sign up because they've come from they usually have an order or they've consented to an order. So they usually sign up straight away. That's no problem. We do intake. You do intake with them separately, same as a mediation process or any process. You see them on their own. We do that via Zoom. I don't know if anyone else does, but I certainly don't see people in person. It's so much easier for everyone's lifestyles these days to find an hour on Zoom. They can be home or, find a room at work or something like that rather than have to drive to where we are. Obviously, I'm in Sandgate, so it means that we can assist people in theory anywhere all over Australia because I usually do it on Zoom or Teams. So we'll do an intake with them separately. Um, and in that intake, we'll also again do, I guess, another suitability test, even though most of them have orders anyway. So hopefully lawyers or whoever's been involved have already assessed them as being suitable to recommend it. But yeah, we always do that suitability test as well. I know in my practice, I check things like how safe they feel, physically safe, emotionally safe. Um, can they be in the same, when I say the same room, I mean the same Zoom room, so the same Zoom space, but in the same space as the other person? Can they hear their voice? Can they see their face? Many of them, most of them are okay with it. Obviously, not all of them. Why I say most are okay is, again, these are people that have been recommended to engage in a process where we're assisting them in communication. So they're usually open to it. People that aren't communicating at all, perhaps they've got a domestic violence protection order that contains restraints, or they might have even a parenting order that contains restraints, and they're not communicating at all, or they mightn't even be suitable in the first place. So most people are okay. Some people, understandably, aren't okay. So we do all that assessment in that first intake. We take them through exactly what to expect from the process. We give them some information. We assure them that it's going to be okay. We answer any questions they have. And then that's when you, as the PC, work out, well, what is my process going to be? Is it going to be joint sessions? Is it going to be separate sessions? We find out then, we usually have your family report because, again, we get it as a referral. But if we don't, I'll ask then, can I have your family report? Can I see it? I check who the lawyers are in it. I check who the ICL is if I don't know already from the referral. So we find out all of that. Fees. Every PC, it's personal what they charge as their fee. Most of us charge our hourly rate. So intake is about an hour. So you'll be charged by me for that. And then it's, I usually do one session a month with the parents joint. If I'm seeing them separately, we tweak that. But you expect to see your PC about once a month. If there's something pressing, and we tend to have a lot, for example, in the lead up to holidays, people want to get in because they're unsure about counting their days for holidays, which I know sounds really simple to us, but But I understand it. We write half holidays and it's like, oh, it's an uneven number and what time does it start? So they might want to get in before holidays. They might want to get in before school change because a lot of decisions are about schooling. So you work with your parents, but generally I'm once a month. Everyone's different. I think that's probably what most of us are doing. The beauty of it is if you are in a joint session, you halve the fee. So I think it makes it, these are often people that are going through court anyway. So they have the, I won't say burden because I'm a lawyer too, but there is a burden with legal fees, let's be honest. So I don't want to, and I suspect most PCs don't want to add to that burden. We want to alleviate it. But of course we're going to charge. So my process is, and I think most of us are, this is the fee, and if we have a joint session, you pay half each, so it makes it much more affordable. So mine, for example, is 500 plus GST for the joint session, so they pay 250 each. And once a month, that's most people find that okay. If they don't, I guess we've got something to talk about. So that's usually the expectation, but as I said, you do get clients that want to see you more frequently. Um, After final orders, you will see clients who have orders that might say see a PC for 12 months or see a PC for up to 24 months. So we work with that and we put that into our agreement. So we look at your court order and then we set out our agreement to match that. Some orders say they're jointly paying fees. Some orders say one party's paying 75, 25, whatever. So we match our agreement to suit your order. So we always want to see your order. And your order will say, as I said, 12 months, 24 months, whatever. The longer you're working with a family post final orders, I find it's monthly, monthly, monthly at first. And then you find families naturally say, actually, Sarah, we can push that out to 6 months. We can push that out to potentially sort of 2 months as things are easing for them. Obviously, I think we're bound by the court order. There is an order and it says Sarah Cleeland or whoever it says. So I'll work with the order that I've got. I'm still an officer of the court. If it says 24 months, I'll do 24 months. But that's the frequency of it generally. That's the way it works. So intake first, work out the pathway they're going to take, what suits them, and then we just get going. And as I said, every now and again a lawyer will ask you for a report, but most of the time if lawyers contact me, I'll just say, oh, you've got their outcome letters, and that usually suffices because my report won't say any more than the outcome letter. We're not family report writers. We don't do evaluations. We just do PCs. So there's no magic. I don't think in our reports. It just says they came along. This is how we assisted them. Yeah, it's a very different report to what you might get from a family report writer. So don't have an expectation of that from us because that's not our skill set.
Very interesting, Sarah. And can you tell us where you have seen some really positive outcomes through parenting coordination, where you sort of either a case where you think it's worked really well and sort of set parties up and on their way, and they've come from a parenting relationship which is not good,
Yeah.
and that process has really helped to rebuild things?
I think for me, probably, there was one particular family where it was just every time in my mind there was the slightest, I was going to say tweak, I shouldn't use that word, but a mistake perhaps or a misunderstanding. It was contravention, contravention, contravention. I think one of the families I saw, they were up to about 14 contraventions. For me, the success was there has been the contraventions that were outstanding or applications that were outstanding when I started seeing them have been withdrawn. And there's been no further contravention applications filed. And that's because those areas where they thought, oh, the remedy when she came on Sunday and it was supposed to be Saturday on my counting at the end of holidays, or she came at 3, but it was supposed to be 12 on my reckoning, or someone didn't report an attendance at a doctor, whereas I thought that came under significant illness, those clauses we often put in there as lawyers, what does it keep each other informed of any significant illness or injury or something, yeah, but he didn't tell me this, blah. So often if they're going through court, they might think the remedy is we just breach, we just apply to the court and seek a contravention. We go to our lawyers and we get a letter written. To me, the success is you see that fall away and you see that they are working through those with the PC, and not having then to approach the lawyer and get a lawyer letter, or seek go to the court and seek a remedy through the court. So they're the outcomes that I like. I like seeing in some of my family's decisions about schooling, whereas they weren't able to make them, we work through, because again, and I'm a lawyer too, we write orders and say, under the old term, equal shared parental responsibility, I know the terminology's changed, and then we say bye, and they then have to go and make the next big decision, which is a schooling decision or a decision about an extracurricular activity. They're probably the main ones, or a decision about a GP, or a decision about medication. So that's where, for me, you sort of go home, high-fiving yourself a bit when those decisions are resolved in PC and they are agreeing, oh, we're going to do soccer at, the local Rockets Club. We're going to send, our daughter to this school. They're the nice outcomes. They're the outcomes that I really like, because it means that a judge doesn't have to make that decision for them and impose that on them. They don't have to go through that process of lawyers. We see a shift in communication. When it first starts, you see parents using a lot of legalese. They think they've got to write like their lawyers wrote. We have parents still calling themselves, the father says this, the mother says that. It's like, can't you just call each other your name? Or they call each other Mr. or Miss. Again, you were with them once, you had children with them, you loved them once. So we see a shift in the way they communicate, moving from those bad habits. We see a shift in talking about or sharing experiences. So again, these are parents that have gone through the court system and they don't share the good experiences because they're almost at war, and they only share the negative. And I'm getting parents to say, little Freddie tried this last night, or he ate this, he tried something different, he won an award, and then sharing that with the other parent and realizing it's actually okay to share the positive. We don't always have to be blame, because for some reason I think they think when they're going through court, the way to, in inverted commas, win is to put the other parent down somehow and be critical. And particularly in PC, we're seeing the other side of that, which is all of us as PCs, we want to change that language entirely, be entirely child focused, not litigation focused. This isn't about, winning, whatever that means, in court. And it's about communicating together, all for and in the interest of your children. So I'm deliberately avoiding giving you specifics because it's, I'm just not sure who's going to listen to this. So I just, I don't want to do specifics, but that's the good stuff. And I suspect that's, if you, and you'll start meeting more and more PCs because there's quite, it's just such a terrific process. But when we talk to other PCs, that's what we're getting out of it, is the highest conflict parents are being sent to us. That's why they're getting the referrals. It is hard work. It's not easy. They don't like each other. They're guarded. So any softening and that move of, rather than communicating almost in a triangle, so instead of going across with each other, they go, as I said, through the PC or through a judge or through a lawyer, you start to see that communication go through the two of them. And that's when you think, I'm getting some traction here. And that's another reason why, at first, probably naively, when I started doing PC, I thought, oh, I'll only need a couple of sessions. I don't know why I thought that. I can see now why I probably do 12 months as an absolute minimum. So you're 12 months to 2 years, but just certainly 12 months, because the change is slow. And as I said, subtle. Again, we're dealing with people that, at separation, felt it necessary to not just engage lawyers, but go to court. So these are people that completely broke down their communication, usually. And we're now rebuilding again. As I said, for their betterment, I'm sure it helps their mental health and their life not to be at war all the time. But the goal is it's a child-focused process. So it's all about giving them those tools for the sake of their children. Yeah, making life easier.
Very interesting. Thank you. Thanks very much for talking to me today.
You're welcome. It's been a pleasure.
Thank you.
Thank you for listening to Flipper Talks, a family law podcast. We hope you enjoyed the podcast today. We confirm that the information we discussed today was just that, information for educational and entertainment purposes only. It is not specific advice. If something discussed has you considering whether you should take steps, it is important to make sure you get professional advice about your unique situation before you proceed, whether that be legal, financial, accounting, medical, or other advice. Please reach out to Flipper if there's another topic you'd like explored, and if you know someone who might benefit from the show, remember to tell them about it. Thank you for listening.